Shimmer, sparkle, captivate. Nothing less than a masterpiece. Droplets of gold inspires precious design. Platinum bursts with intricate freshness. And every pure diamond becomes more than just a girl's best friend. Voda Gold Gem Jewelers, where timeless dreams become a reality. We tailor-make designer gold, platinum, and diamond jewelry. Trade in or remodel your old gold. Clad yourself with classy name-branded watches. We offer insurance valuation and freezer card calculation. Visit us at 534 Ridge Road, Overport, or call 031 208 9142. Voda Gold Gem Jewelers, manufacturers of fine gold and diamond jewelry.
The Al Ansar Foundation, Da'wah, Tarbiyah, and Education, establishing the foundations of Islamic civilization in South Africa.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والعاقبة للمتقين والصلاة والسلام على رسوله الكريم سيدنا محمد وآله وأصحابه أجمعين برحمتك يا أرحم الراحمين. All praise due to Allah, the Lord, Cherisher, Nourisher, Sustainer and Master of the universe, the most gracious, the most beneficent, the most merciful. Ya Allah, it is only you that we worship and it is your guidance that we seek. Ya Allah, keep us in the straight path. Ya Allah, shower us with the choice of blessings. Ya Allah, shower us with your mercy. Ya Allah, guide us. Greetings, salam, salutations on our beloved Nabi Muhammadur Rasulullah sallallahu alayhi wasallam. It's now 12 minutes past 7 on this Tuesday evening, the 2nd of September, this Monday evening, the 2nd of September 2024. Assalamu alaikum wa rahmatullahi wa barakatuh and welcome to Business Matters on Radio Al Ansar. My name is Faizal MJ Suleman and I'll be your host this evening, inshallah. We are discussing the complexities of power of attorneys in business, and our very special guest today is Johannesburg attorney and Nazneen Khan. Nazneen, assalamu alaikum wa rahmatullahi wa barakatuh and jazakallah khair for joining me on the program this evening.
Assalamu alaikum.
Wa alaikum salam. Nazneen, thank you for joining the program this evening. Just to introduce our guest, Nazneen is an attorney. She practices as BP at BPG Incorporated. She's a notary. She's a co-founding director of Dignified Dispute Resolution. She's a board member of AMUR, that's the African Institute for Underwater Research, Education and Exploration. She is currently working towards the solicitors qualifying examinations of England and Wales in order to increase her knowledge and broaden her opportunities of working in common law jurisdiction environments. And she is somebody that I personally am very, very proud of, and she's done extremely well for herself. Nazneen, congratulations, well done, and thank you for joining me on the program this evening. Now, Nazneen, as I said, our topic for discussion is the complexities of powers of attorney in business. Let's start the discussion by just telling us what is a power of attorney.
Jazakallah so much for having me on the show, Uncle Faisal. And I have to say, before I go into the powers of attorney, it's always nice listening to your show. It's always nice being here. And I don't know where you guys got that extensive bio from. It makes me a little humble because I don't read it often enough. But yeah, Jazakallah so much for the sentiments and for the bio and the wonderful introduction. Just to talk about the challenges and the limitations of power of attorney and to explain to the public what exactly, to introduce what powers of attorney are. I'm going to say firstly is that it's so important to at the offset explain this because there's a lot of people who do not understand what this is, or rather they think they do, but they actually don't. And it's surprising because many people get themselves into trouble for something like this. And it's a scary thought because a power of attorney is an extremely important document. And if not one of the most dangerous documents to give someone if you don't understand what you're doing, or rather how to do it properly. So in a general sense, a power of attorney is a written, legal, binding document whereby you're granting an authority or a mandate, as we say in attorney talk, to a person to act on behalf of another person. So you're giving them basically a power to perform actions on your behalf. So not in terms of necessarily a business, if you're looking at just a general sense of people giving letters to other people to go and pick up their ID book or go and pick up this, that essentially is a power of attorney, and it's a power you're granting to somebody else to perform actions on your behalf. So the one being given the permission, called the agent, the one giving the permission, called the principal, and the permission being given is for the agent to act on behalf of the principal for something, or the company, as we'll discuss in today's talk.
Mhm. Just to remind our listeners that this is an interactive program and we have an expert as our guest this evening. If you have any questions on powers of attorney, please forward them to us via WhatsApp on 060 904 1056. I repeat, 060 904 1056. Now, Nazneen, what are some common challenges that businesses face when implementing powers of attorney documents?
Uncle Faisal, I think the amazing thing about this is that businesses are constantly facing not just one, not just two, but numerous challenges when it comes to something as simple but important as a power of attorney. I'm just going to highlight a few. Firstly, powers of attorney that are drafted in a vague and ambiguous manner. I cannot stress enough how much of consequence that is attached to powers of attorney that are drafted so vaguely and ambiguous. What this means is that the power of attorney is not drafted clear enough to understand what exactly the powers are granted to a particular person. And this then leaves the power of attorney open to dispute, abuse, or unintentional irregular use of that power of attorney. So this usually becomes a problem, when a holder of a particular office has certain duties of office to fulfill, and then unintentionally they use it outside the scope of what they're allowed to. For example, maybe someone holding an office where they need to sign a loan that they're not supposed to. This becomes problematic with contractual disputes because parties to the dispute, they start arguing whether the person signing had the capacity or the authority to sign on behalf of the company or not. And then this can obviously then lead to ambiguity about the scope of authority granted to that agent or that person that's holding the power. And this ambiguity can cause internal conflicts or disputes with third parties. For example, as an attorney, I see numerous disputes on contractual claims where people have signed contracts on behalf of their company, and they're actually not allowed to sign those contracts on behalf of that company. They haven't been granted the power to do so. Then another challenge is the fact that businesses just lack proper understanding, I think, of the legal implications of this power, in a sense that there's no training, there's no steps taken to help everyone in the business learn more about how this works because, they think that the concept is very simple. They think they already know this. But what this in turn does is it causes disputes in that relevant department or outside, resulting in the agent, that is the person being given this power to perform actions not within the scope of this power of attorney, and also not aligning to the values of the business or the objectives of their position. That's just two. And then another is that there's a large potential for the abuse of power of attorney, alternatively, fraud. So if the power of attorney is drafted, for example, in a manner that is not specific enough, the resulting cause would be that the agent would in turn abuse this power of attorney by using it outside the scope of their duties, or in some cases fraudulently, to take personal loans, enter into agreements that they would not otherwise allow to, and then they bind the company to this. Just to explain this a little bit more, there was a case where there was this lady who was appointed, she was granted the power of attorney to make payments on a more smaller scale, so like petty cash payments. And in effect, she actually fraudulently used this power to make personal payments on her behalf. And this was never checked. It was never balanced. There was no accountability. And it was only found out like 2 or 3 years later when it amounted to approximately 2 million. So, I mean, this power of attorney, if it wasn't obviously drafted properly, so it granted her the authority to make all these payments, and then there was no checks and balances. Then another major challenge is that, well, not a major challenge, it's more like you need to basically learn the different jurisdictions and the relevant rules about how power of attorneys work, because obviously there's certain people granting power of attorneys to people in different countries to act on their behalf. For example, if someone's like in England and they're granting a power of attorney to people in South Africa, they obviously need to pay regard to the rules and regulations of that. And then there's the notarial thing that comes into effect with the authentication. So those are some of the challenges that companies would face, because they need to in order to properly execute this power of attorney, they need to pay regard to those rules. Yeah.
I think what you said is very important, because we need to comply with all the formalities. Many of us just simply
Yeah.
sign a power of attorney. They think they get it commissioned, certified by Commission of Oaths is going to work. But as you said, if it's used in another country, then some countries ask that it needs to be notarized. Some ask that it be authenticated by the high courts, by the
Yeah.
registrar of the high court. Some even ask that it be authenticated by their embassies or
Exactly. Yeah.
any locally. So one has to comply with all the formalities. Now, there's a question that's coming from one of the listeners, and the listener says that you spoke of companies giving powers of attorneys. Does a resolution taken by the board or taken by a meeting of the company authorizing a director or an agent to act on behalf of the company serve as a power of attorney to that particular agent? So we're not talking about
Yes, it
express. Sorry, we're not
yes,
talking about express
it
power of attorney.
essentially
We're talking about a
does.
resolution. Yeah.
Yes, a resolution. So essentially it does, but what usually then happens in a company is a power of attorney, in most cases, in order to provide like double protection, a power of attorney is usually, in other words, granted still by virtue of that resolution. So the resolution would usually be taken in order to grant a power of attorney to some person to act on their behalf, and then the power of attorney is then drafted to grant them the powers and then to identify the scope, because the resolution would ultimately just say that a power of attorney is being granted in this respect. So the resolution might serve as a power of attorney, but I think as a double measure, you should take a resolution to be able to grant that power of attorney and then still draft a properly defined power of attorney, identifying the scopes, the cross checks, balances, maybe the termination clauses and that sort of thing, which ultimately wouldn't be in your resolution.
So how can businesses then ensure that the powers of attorney granted under a power of attorney, or that the powers, sorry, granted under a power of attorney are clear and specific enough to avoid conflicts of misuse?
So I think, as I mentioned earlier, that businesses firstly need to take the time to gain knowledge on the implications of powers of attorney, and consequently then learn how to properly draft them for each given purpose, because obviously different powers of attorney comes with the different challenges and comes with different clauses and that sort of thing that need to be in the power of attorney. So number one, they would have to understand the basic and important provisions that need to be included in order to avoid the ambiguity that I spoke about earlier on what is being granted to the agent. And this requires one to draft with precision. So you have to clearly be able to define the scope of power that this person will have. So, for example, you will need to clearly set out exactly what actions they will be permitted to do and for what purpose. If the manager of a finance department, for example, in your business is being given the power to, say, hire employees under him, or appoint auditors or accountants or pay them, this scope needs to then clearly define that they're able to sign contracts on behalf of the company, and also define exactly what type of contracts, like, for example, a contract of employment, and for what these contracts are to be used in that department. He cannot, for example, say sign contracts binding the company to an investment or a car purchase or anything like that. So that's just one. Two, what we can do is you can set limits for the power of attorney, which is also important. So sometimes you'll need to grant an authority to a person in a certain office that is on a lower, more ground level of the company, such as the scenario I spoke about earlier, which was somebody that was responsible for petty cash, such as the power to make payments on behalf of a company for small things. So you will need to maybe then set a monetary limit to ensure that that ground level employee is not authorizing payments for millions of rands, and then and you binding the company to millions of rands, you're spending millions of rands of the company's business on something that you maybe don't have the scope to do. So if you set that monetary limit and you say that if it's 100,000 rand and over 100,000 rand, this needs to be checked by a third person. That's something that a business can do to ensure that it's specific enough. Another way that you can protect your business is maybe, like I said earlier, it's a very complicated thing that seems very simple, but maybe consult with an attorney when drafting a power of attorney. I think the important thing to remember is not to assume. It's simple, and you don't assume you know what you're doing. Have an attorney draft it, or at the very least, have an attorney take a look at it to ensure that it adequately provides for the purpose of the power of attorney and still protects your business, because that's ultimately what we want to do. We want to be able to have our employees or whoever is in that office perform their functions of their duties, but we also want to protect the business at the end of the day. Then we can also, regularly update or review the power of attorney granted, especially in the case of general power of attorneys, where the time limit is not defined. So it's important to oversee how this power of attorney is being used and then review maybe the scope or the limitations and update them as they need be. In fact, better yet, set a time limit for the power of attorney, and on that period of ending, renew it as you see fit, so that there's checks, there's balances, there's accountability. And in fact, maybe another method of accountability could be that you have a protocol. Have this agent or this person being granted the power basically record everything that they've signed, everything that they've done in the use of that power of attorney. And if something, and that needs to be checked, maybe weekly, maybe monthly, and if it's not in that record, it obviously falls outside of the scope of what they're supposed to do. So I think that's just some of the ways.
Yep, you did mention somewhere along the line general power of attorney. Now, what is the difference between a general power of attorney and a special power of attorney?
So a general power of attorney is basically a power of attorney given in a general sense. And when I say this, what I mean is that you don't have a clearly defined period or a clearly defined job that they're doing. If somebody is in a specific department of a company, they have a general power of attorney to perform all things within that company, to perform their duty. So it doesn't define exactly what you're supposed to do. It's a more broader approach. For example, an attorney calls it a mandate. So in terms of the mandate will basically say that we have the power to act on their behalf and represent them and do all things in our power to issue summons and to recover a certain amount of money. So whether that means us issuing summons, whether that means us going to court, whether that means us speaking to other people on their behalf, that's a very general sense. And it also doesn't really have a defined time. Whereas a special power of attorney is a power of attorney issued in respect of a specific action. So if you're giving somebody a power of attorney, for example, to go and collect your ID book from the department, that is for a very specific action that you're doing, or you're granting somebody a power of attorney to maybe sign a contract on your behalf because you cannot make it to a specific meeting. So you take a resolution, you grant a specific power of attorney or a special power of attorney, as we call it, for them to go there, and all they need to do is sign that contract. So it's very, very specific.
Another question has come through, and I'm glad this question came through because I was going to ask you that question as well. You spoke of termination, etc. Now, what happens if I grant somebody a power of attorney and I die tomorrow? Is that power of attorney still valid?
I think it really depends on the scope of that power of attorney and what your functions are. A power of attorney ultimately comes to an end when a person dies. So if you forming a specific function and then you die, that power of attorney, you cannot act on behalf of a person because you actually have to have legal capacity in order to grant somebody legal capacity. But in a case where you're granting power of attorney for certain bank accounts and that sort of thing, and that power of attorney is granted, but then ultimately that also wouldn't really hold, because then when you are granted power of attorney for someone who's incapacitated, then there's a whole other legal process. So I would say that somebody needs to be very careful about following on that power of attorney if the person no longer exists, and it really depends on the scope of that power of attorney.
Yeah, in fact, I
and
think
the purpose of it.
Absolutely. In fact, I think the general rule is that the power of attorney terminates upon death.
Terminates upon,
terminates upon death. so that if anybody wants to act after that, then they need to become an executor in the state. But
Correct. Correct.
having said that, I think we need to take an ad break. But just to remind our listeners that if you have any question on powers of attorneys, you can forward them to us via WhatsApp on 060-904-1056. We're going to be visiting the marketplace. Nazneen, do stay with us. We'll continue after this, inshallah.
Jazakallah.
This segment is brought to you by Kenfield Auto, your RMI approved service and repair specialist. 236 Brickfield Road, Overport. Kenfield Auto.
بسم الله الرحمن الرحيم ربنا وآتنا ما وعدتنا على رسلك ولا تخزنا يوم القيامة إنك لا تخلف الميعاد.
Car won't start?
Kenfield Auto.
Noisy brakes?
Kenfield Auto.
Due for a service?
Kenfield Auto. Kenfield Auto, the answer to all your car problems. Your service and repair specialist for your VW, Audi, Suzuki, Toyota, or just about any vehicle. Kenfield Auto, your RMI and insurance approved workshop to handle them all. 236 Brickfield Road, Overport. Call us on 031 207 2399. Kenfield Auto.
Would you like to give Sadaqah 365 days a year? You can with the Al Imdad Foundation's Daily Sadaqah program. Donate as little as R1 a day for a month for each member of your family, up to any specified amount, and receive monthly feedback on where your contributions have made a difference. Visit alimdad.com and download your Daily Sadaqah debit order form or call 0861 786 243 for more information.
The Al Ansar Foundation, Da'wah, Tarbiyah and Education, establishing the foundations of Islamic civilization in South Africa.
If you listen to Business Matters on Radio Al Ansar, Business Matters is brought to you by the Minara Chamber of Commerce.
بتر وفي جمري أدعوك يا ربي أن تشرح لي صدري تهديني لتقواك بتر وفي جمري وفقني لمرضاتك يسر حفظ آياتك وفقني لمرضاتك يسر حفظ آياتك سبحانك قد يسرت قرآنك للذكر.
You're listening to Business Matters on Radio Al Ansar with myself, Faizal MJ Suleman, and Business Matters on Radio Al Ansar is brought to you by the Minara Chamber of Commerce. Our special guest this evening is Sister Nazneen Khan, who is an attorney practicing at BPG Incorporated in Johannesburg. And of course, we are discussing complexities of power of attorneys in business. Now, Nazneen, what legal limitations or requirements should businesses be aware of when drafting and or executing a power of attorney?
Jazakallah. Thank you for welcoming me back. Regarding your question, I think I've already highlighted some of these, but to be more specific, we can start with the formal requirements, because obviously at the beginning of the show we spoke about how important formal requirements are in executing power of attorneys. So a power of attorney must meet formal requirements under South African law, such as the fact that a power of attorney should always be in writing, it should be signed, and it should be witnessed. In the case of companies, a properly regulated resolution taken, such as what we spoke about earlier. That resolutions are very important, especially when you have to be in a position to grant a power of attorney in order for you to give the power of attorney. So in South Africa, a power of attorney must generally be signed by the principal, that is the person granting the power, in front of witnesses, and a resolution by directors or trustees to grant this power of attorney must properly be taken. So when I also say the resolution must be properly taken, obviously there are certain requirements in terms of the Companies Act that need to be followed in order for a proper resolution or proper quorum to be called in order to take a resolution. And these must be signed, obviously, properly in person or whatever the requirements are for that particular resolution that needs to be taken. The other legal limitations that businesses should be aware of is, as I said earlier, the document should be specific about the powers being granted to avoid overly broad or vague language, which could lead to challenges or limitations in its enforcement. So it needs to clearly define what they're allowed, what they're not allowed to do, and that sort of thing, because I feel that's something that's very important to be able to enable a certain person to perform their functions, but also limit the ability or limit the capacity of them to commit fraud or maybe negligently use that power of attorney, if we could say. Let's not directly accuse them of fraud. Some people don't understand how to use a power of attorney because they just think that they have this power to do whatever they need to do in terms of this power of attorney. But I think they need to be able to properly identify what their scope is. It's also important to identify whether the principal has the legal capacity, like I said, to grant a power of attorney. As I mentioned, the resolution. Alternatively, a position that allows them to grant the power of attorney in favor of the agent. So they must be of sound mind. They must be able to understand the implications of the document before they grant the power of attorney. And this is not just in terms of businesses. This is also in terms of what we spoke about before we went on the ad break. That, if a person is not of sound, if a person is granting a power of attorney, a normal person, and if they're unable to do something and that is why they're granting a power of attorney, it's important to identify whether they're actually lucid or whether they have the capacity to understand the implications of the document, which in effect, like any contract, would render it invalid. Also, you absolutely have to have a revocation clause. So you need to include clear terms on how the power of attorney can be revoked or terminated to prevent ongoing liability if the business relationship changes. So many people do not have this, and it becomes a problem because ambiguity plus a lack of revocation clause can cause immense abuse of power of attorney. So say you grant a power of attorney to someone to make payments to the accountant. Maybe it was meant for a specific purpose and a specific account to service. This clause firstly opens the agent up to making payments of millions to the accountant for absolutely nothing. But what I should say is the power of attorney granted by so-and-so to make a payment to the accountant who is named so-and-so for the services rendered on such and such a date to set up a trust or whatever the accountant did. So the authorization monetary amount, maybe that, as you spoke about the limitation earlier of the monetary amount, is say 20,000 Rand. It should not exceed 20,000 Rand without the authorization of a head of department. And then you need to include a lapse once the payment is there. So you need to be able to include a lapse date or a revocation clause.
Now, if we've forgotten the revocation clause, supposing it's not there. Now, obviously, the principal, or rather, does the principal have the power to just unilaterally revoke that power of attorney at any time if there's no revocation clause?
Sorry, just repeat the question.
You mentioned that we should ensure
A
that there's a
revocation clause.
revocation clause. Now, if we've omitted the revocation clause, because many of us don't think of including the revocation clause.
Yes.
Now, does the principal have the power to withdraw or to revoke that power of attorney at any point in time?
Of course, because the person is acting on your behalf. So a person who grants a power to someone can revoke a power of attorney at any given point in time. And this is in a general sense, not in a business sense as well. In a business sense, obviously, a resolution would then need to be taken for everybody to consent that this power of attorney needs to be revoked. There's no one person that can make a decision. So once again, a resolution would then be needed to be taken. And obviously, that person cannot abuse a power that is being given to them, and they can revoke it at any given point in time.
So even although the revocation clause, would be an added advantage with belts and braces,
yes.
Even if it's omitted, I mean, it's not a chain smash because the principal can still revoke that at his leisure because he's granted that particular power. Is that correct? That's one clarification.
That is correct. But what usually happens in terms of the protection of a revocation clause is the revocation clause would provide for certain provisions on maybe the revocation, like if a person has So maybe the power of attorney was granted to one of the directors, and the directors obviously is also part of the resolution that needs to be taken. So the revocation clause would include under what criteria this power of attorney should be revoked. This would not cause dispute then among why this power of attorney should be revoked, and it would ease the transition of the resolution that needs to be taken, because then there would be no doubt that this action was performed and the clause and this power of attorney needs to be revoked. Whereas if you want to revoke a power of attorney and you undertake to do a resolution, there might be some directors that might dispute the fact that this should be revoked. So I think a revocation clause is very important to include.
Thank you for the clarification. Now, can you discuss any recent changes in legislation or regulations that have impacted on the on the use of power of attorney in business context?
Well, there has really been no major recent changes in South African legislation, specifically regarding power of attorneys, or at least none that I've heard of as yet. But businesses should always remain vigilant in any case about any updates in the Companies Act or the new regulatory guidelines that might affect the use of power of attorneys in their corporate governance. Additionally, international businesses must be aware of changes in foreign jurisdictions, especially regarding electronic and digital power of attorneys, especially in light of these AI things that are happening, as many countries are adapting their laws to accommodate digital transactions and electronic signatures and that sort of thing. So what's just very important is to keep updated on what your duties are as directors, what your fiduciary duties in terms of the Companies Act when granting power of attorneys, how these affect your resolutions, how legislation maybe changes in different countries for the authorizations in terms of the Hague Conventions and how these are to be authenticated. But as far as I understand, there's not been any recent changes specifically to powers of attorney that I know of.
And how can businesses then protect themselves from potential abuse or fraud involving power of attorney, the authorization that they give for it?
It's really all the things that I've already mentioned. If people take into account, for example, constantly training your staff and yourself on how these are to be drafted, know what you're getting yourself into, define the scope properly, not vaguely, have your termination clauses and your revocation clauses in, perhaps get an attorney to take a look at it, as I mentioned above, then you're steps closer to protecting yourself. And the other things that you can look at is choosing the right agent, that is the person you're giving the power to. Only select trustworthy people with strong track records. So this person should understand the business, be aligned with these values and goals. Don't just give a power of attorney to somebody who's just come into the company and you don't trust him to do payments and that sort of thing, or maybe have it just very specific and not grant them the permission to make payments until you absolutely trust them. Then also, as mentioned earlier, there's always important to implement the checks and balances in the process, like establish internal controls, such as requiring dual signatories on high value transactions, or regular reporting, like I said, the protocols by the agent, which needs to be checked, which needs to be reviewed every week, is preferable, but if not possible, then every month. So accountability is very, very, very important, because ultimately your agent is acting in the capacity of the principal, and ultimately it's the principal that holds the fiduciary duty to act in the good cause of the business. So anything that your employees do, it falls on you to overcheck, to oversee. So if you're not doing that, then obviously the liability then falls on you as well. And also include revocation clauses, as I keep mentioning, that are clear, that allow the business to revoke the power. Those need to define whether there's an abuse of power, and whether what specific actions revoke or automatically revoke, I would say, a power of attorney. In that case, you don't need to hold a resolution, or you need to include your termination clauses. Maybe that's very important. I would think that, that's how businesses can definitely protect themselves.
Thank you for that. The next question has come through from one of the listeners, is that are powers of attorney transferable? And I think what the listener might be want to clarify is that I've been given a power of attorney to act on behalf of a principal, but I'm not available. I'm going away for a holiday tomorrow, can I then transfer it to somebody else to act on my behalf, on the principal's behalf? I'm looking at a bit of a remote power of attorney. Is something like this possible? Now, whilst you're thinking of that, Zach wants to take an ad break. We'll continue on the other side of this, inshallah. Do stay with
Okay,
us now.
perfect.
They convinced the world to believe that terrorists look like beards and thobes. Now, as the facade cracks, one martyr after another, the world sees through the broken windows and now knows the true face of terrorism. It wears suits and ties and smiles behind lies.
Are you or a loved one battling the disease of addiction? Is your family, life, relationships, work suffering due to alcoholism and substance abuse? Zensai Treatment, Recovery and Wellness Center are addiction specialists offering specialized psychotherapy and naltrexone therapy to help overcome addiction. Zensai offers hotel-style facilities to allow your loved ones to regain their dignity and overcome alcoholism and drug abuse in the most comfortable setting possible. Fight addiction. Call Zensai Treatment, Recovery and Wellness Center, the addiction recovery specialist on 031 563 0751.
This hadith is sponsored by Ashraful Aid, International Humanitarian Organization.
حديث أدي قال رسول الله صلى الله عليه وسلم خير الناس أنفعهم للناس. The best of people is one who benefits others. We should always help others. We must sacrifice ourselves and our things to help others. When we help others, they will love us and they will make dua for us.
This hadith is sponsored by Ashraful Aid, International Humanitarian Organization.
Are you looking for a meaningful way to fulfill your zakat obligation? Look no further than Ashraful Aid. With our trusted track record, your zakat reaches those who need it the most in the most honorable and dignified manner. Visit our website at www.ashrafulaid.org.
Join the Al Ansar Cancer Support Group at the Orient Islamic School Fun Day, taking place on Saturday, 7 September 2024 from 9 a.m. to 4 p.m. Visit our store where you can pick up lovely items on sale and support our cause to help, inform and uplift those with cancer. Remember, Saturday, 7 September at Orient Islamic School. See you there.
The Al Ansar Foundation, Da'wah, Tarbiyah and Education, establishing the foundations of Islamic civilization in South Africa.
You're listening to Business Matters, brought to you by the Minara Chamber of Commerce and hosted by myself, Faizal MJ Suleman. Our topic for discussion is complexities of power of attorney in business. And our special guest this evening is Nazneen Khan, an attorney practicing at BPG Incorporated in Johannesburg. Nazneen, just prior to the ad break, a question that came in from a listener was, is a power of attorney transferable? And the context is, I've been given a power of attorney to act on behalf of somebody else. I'm going to be away. I want to now pass it on to someone to act on my behalf on that power of attorney. Is that possible?
Unfortunately not. A power of attorney is not transferable for the simple reason that you've been given permission or authority by somebody who trusts you to act as a representative of themselves. So this power of attorney has clearly defined you, has clearly defined your ID number, and has identified the principal themselves. So you as a unilateral person cannot appoint somebody else because that's not the wishes of the principal. The only time that a power of attorney is transferable is by the principal themselves, which for all intents and purposes, we spoke about earlier whether a power of attorney is terminates on death of the principal. So yes, if a person passes away, obviously that power of attorney cannot be transferred because the principal has in effect passed away and they are the only ones that can transfer or appoint a new power of attorney. And I think just to drive this point a little more, it's something that, a power of attorney sometimes doesn't necessarily look like a power of attorney. There's many instances where we grant people permission to do things on our behalves. That's actually a power of attorney that we don't, ultimately identify at on the offset or at face value. For example, there's a common clause in any will that says that you're granting an executor, that is now you're granting a power of attorney to someone to execute your estate after your death, right? That's the only instance where you're granting a power of attorney to act as your agent. and to do everything to wind up your estate. So in effect, you're granting this person a power of attorney, and then if this person is unable to perform the duties of a power of attorney, the person that's executing the will then appoints a second person who is able to act as the agent. So they say in the case of a person who is in the case that they're unable to or do not want to act as the agent, then I appoint a different person to wind up my estate. So this has to be appointed by the principal.
Thank you for that. What are some best practices for businesses to regularly review and update their power of attorney documents to ensure that they remain effective and relevant?
The protocols that I spoke about, agents that hold a general power of attorney should have protocols of the list of how they use their power. So I think this is something that not everybody does, but I think it's very important for them to actually implement, because it actually holds people accountable or holds a record of what they've done with their power of attorney, in order for the other person to be able to review it constantly and see whether this power of attorney is being used in its proper course. So in saying this, I would highlight that these should be reviewed, they should be overseen, they should be audited as a double check, which is every week and every month. And as I keep mentioning before, is that directors or heads of departments have a fiduciary duty in terms of the Company Act to act in the good cause of business. And it's very important for you to double check what goes out, because ultimately you hold the liability for that. So also reviewing if the power of attorney needs to be changed or amended or altered to suit new rules, regulations, changes, and scope. So sometimes what happens is there's mergers, there's acquisitions of companies, there's a change in ownership, there's a change in management, and sometimes, these policies changed. So it's always important to, especially in relation to leadership, there may be instances where a person may not be able to have the power to hold anymore due to company policy changes. So if there's a change in the way operations work, a person in a specific department may not necessarily need the scope of power that they hold. If, for example, finances, if there's a whole different department set up to do finances, now the person in a different department might not necessarily need the scope of making payments anymore. So it's always important to review these changes, to review how the regulations within your firm or within your business changes, and then you need to adapt those power of attorneys and change them accordingly. It's also always important, like we said earlier, to keep abreast of legislation updates that may affect any power of attorneys, which obviously there's going to be lots of legislation coming into effect now, especially in terms of the AI, which hasn't actually come into being yet. There's many discussions, but there's going to be a lot of things that are going to change. So I think, those are some of the best practices that a business would need to do to regularly review.
Okay, I'm going to pick your brain a little now, if you don't mind. You did mention earlier, but I think that's what attorneys are for. You got to think on your feet.
Yeah.
You did mention earlier that a person must be of sound mind and have legal capacity to execute a power of attorney. What happens if a person is suddenly incapacitated, it just suddenly goes into a coma or gets sick or whatever, and is not in a position to appoint somebody to handle his affairs? How does one, what is the situation then?
You're talking about if there's no power of attorney or anything granted in that respect?
Absolutely.
We've actually had situations like this. Actually, a similar question was asked the other day where somebody wanted a power of attorney to act on someone's behalf who, in effect, is incapacitated and they weren't always lucid. And my advice to them was, obviously, a power of attorney is not going to work, because if that power of attorney is challenged, that person may not have been in their sound mind to enable them to sign any agreement. Because as the law states, a person has to be in sound mind to be able to sign a power of attorney or to understand the consequences of what they're signing. Otherwise, it becomes null and void. So in this circumstance, a power of attorney is not going to do. In this circumstance, there's a substantial application, unfortunately, that needs to be brought court, in the High Court, that enables a person to be granted curatorship of this person and able to handle their affairs. So in this affidavit, in their application, they would need to set out the circumstances. They would need to prove their circumstances from a psychiatrist or from their doctors, proper medical reports, and then only will the judge grant curatorship to either the person applying for curatorship or alternatively a different curator as the High Court deems fit, because obviously you don't want someone abusing the power of this curatorship to use the funds of somebody who's incapacitated. So there has to be a proper made out case for that in order to grant
So the
curatorship.
person's probably going to use his entire all the funds he has in his estate to pay for the substantive application.
Well, it can be brought on. Yeah, unfortunately, sometimes
these are expensive
the law
applications.
doesn't always provide justice, but this is an argument I was having with someone the other day, because I mean, if you need to do something in someone's account now, do you know how difficult it is to actually get a court date in Pretoria and Johannesburg? I don't know Durban now, but in Pretoria or Johannesburg, there's multiple documents that you have to file and submit online in order to even get a date. And then sometimes, with this court online system, it's difficult for them to see. And then you have to go in and you have to ask them for a date. So it's actually a little bit of a nightmare at the moment. But unfortunately, in order to provide adequate protection for this person that's incapacitated, a power of attorney is just not going to do, because this person doesn't understand the consequences of granting that power of attorney before they grant it. So it's ultimately null and void.
Yep. Nazin, I want to thank you for joining the program this evening. Undoubtedly it's been very educational, and we've covered, I think, almost everything regarding power of attorney. But I'm sure you have a message for our listeners.
The message is basically everything I've spoken about. We need to understand the different types of power of attorneys and their applications in business so that we can help our businesses navigate the legal complexities of delegation and authority. And we need to ensure that they are protected against potential risks while maintaining our operational efficiency. So I think at the end of the day, as a business owner, as a director who has the ultimate responsibility and liability for the continuity of your business and for the implications or consequences that arise thereof, you need to properly draft your power of attorneys. You need to either get an attorney to check them up, at least for the time being, and properly train your staff. So just learn.
Absolutely. Nazin Khan, thank you very much for joining me on the program this evening, and I wish you well. All the best to you. Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam. Jazakallah for having me.
Absolute pleasure. Absolute pleasure. We spoke to Nazin Khan, an attorney practicing at BPG Incorporated in Johannesburg. She spoke to us about powers of attorney. Time for me to bid you farewell. I want to thank Zach for having engineered for me in our studios. Zach, thank you very much for a job well done. And of course, I must thank Sister Sister Amina from Minara for having produced the show. Amina, thank you very much. Most appreciated. And thank you to the Minara channel for giving me the opportunity of hosting this program. The next program you're going to be listening to Radio Ansar is Q&A with Mufti Abdul Qadir Hussain. And inshallah, that will take place immediately at 8 o'clock, inshallah. So till then, for myself, Faizal MJ Suleman, all the best to you. Assalamu alaikum wa rahmatullahi wa barakatuh.
The views and opinions expressed by the presenters and guests of Radio Al Ansar are not necessarily the views and opinions of Radio Al Ansar.